No, you just cross it through.
All set?
I think I'm all
All
set.
good, man?
Yeah, I'm getting logged into my email.
Let's all keep asking.
Who wants to know things good?
I really appreciate the level of care.
It's the old
Gotta get my hat that says I'm good.
I want to make sure Ben's good.
You keep saying that the only thing I'm seeing now, Gary, is it's not, okay, how about if I hit approve? Maybe that'll work.
Sounds
there
like
we
what
go.
you're saying is the long-term Cali folks all know that they help.
Yeah, that is exactly what they're saying.
That's what I'm just saying, that we all have such respect for Ben, we want to make sure he's okay.
Yeah.
But you may be right.
Oh, it's on board. Yeah.
Gotta get you a hat that says I'm good stuff, man.
Well, on that note, I gotta hit the restroom now.
Yeah, right, that was what I didn't get to. Again, speaking of long-term care.
You're worried.
Oh, hey.
We're trying to start playing straight. All right.
Of course, I should probably mute my screen and
Memorial Day was over.
show out my.
Washington DC on Tuesday.
Friends, we'll get started in just 2 seconds. I'm running just a second behind.
So Tom's not here, David's not here, John Burns is not here, there's not gonna be anybody in our audience this afternoon. Damn.
That's pretty much the core of our,
Good, man.
Hey, Chris.
heckling.
How are you?
I'm technically years.
It's a pull, not a push. We push down and pull back. Yeah.
Remotely.
Much easier the second time.
I know, yeah.
Okay, yes.
Harold, how do you like Sony? This is the Gen 2.
Okay. Yeah, we had pilot of that. Yeah.
Gen 1 is actually better because it's automatically synced with a cloud storage.
Okay.
This one doesn't. You can step back.
What do you have to plug it in?
It does wireless or Bluetooth to your desktop, laptop.
So there's a device dependency and then a service dependency.
And I think enough people scream about it is now they've created an app for your phone.
Okay.
Friends, it is now 11:03, so I'm going to go ahead and get started. I think I'm being videoed, and so Gary says thumbs up, I'm being videoed. So hello, video world, and thank you all for coming and for being here. My name's Ben Chapman, and I'm the Executive Director of the Legal Analytics and Innovation Initiative at Georgia State College of Law. Yay! That was a yay for getting through that title, which I appreciate. For years and years, I used to come to Cali and talk about whatever weird little tech thing I was into at that moment. And so this is a change for me. I spent 15 years as IT director over at Emory Law School in Atlanta, and I've moved down the street and across the world to Georgia State. But my role now is really program development, program support, and also technology. We're exploring some different technologies in this new initiative, and we want to share that with you, share this information with you, and talk about some of the exciting things that are happening at Georgia State. This is a fascinating program. I think it's an interesting hint at some of the things that we're going to be exploring over the next 4 or 5 years. It's also a new program. It's a delight for me to work in a very mission-driven environment at Georgia State's College of Law. and I'm just excited about having this, this opportunity to do this. Now, some of you may be in the wrong room. So here's the TLDR. You can leave, bail, you know, go have some other, do some other things. There's a lot going on here. By the way, this building's gorgeous, Gary. I know how much work goes into that kind of thing. And it's a great space. Thanks to Callie, by the way, for letting me be up here. So here are our points of pride. One of these days we'll come up with something better than points of pride for things like this. I'll just call it the TLDR. In the first year of this program, we looked at lots of stuff. 68,000 docket sheets, 50,000 FINRA arbitration awards, 140,000 filings with the SEC. In our experiential lab this spring, 68,000 cases, employment law cases. The other thing that we've done in a year of really hard work, and I fortunately missed all the hard work. Professor Ann Tucker and Professor Charlotte Alexander at the College of Law spearheaded this. But we developed a certificate in legal analytics. We'll be talking a little bit about that. 21 credit certificate. A dual degree in law and analytics, which is a testament to the very strong partnership between our business school, the Robinson College of Business, and the College of Law. And then also an LLM with a concentration in legal analytics as well. One of the things that is fascinating about being at Georgia State is it is truly an entrepreneurial institution. This law school has only existed since 1982. There's an interesting connection, by the way, between Emory Law. One of our very famous deans at Emory Law retired and then became the founding dean at Georgia State College of Law. Emory made a decision to drop its night program and part-time program in move in a different direction, and Georgia State took that on. Cool stuff. Anyway, but one of the things about Georgia State being so entrepreneurial is that we do these sprints. We partner with local law firms, and we are constantly on the lookout for opportunities to partner with local law firms. Atlanta is fortunate to have a significant local legal ecosystem, and so we've been able to partner with these firms. But we've been working with Alston and Bird, training them in this area. We're partnering with some other law firms as well in the area. One of the things we're very excited about is 3 of our graduates are now working at law firms in legal analytics related jobs. And that's exciting stuff. We can all have a discussion about the JD advantaged versus JD required aspects of this, but the whole profession is going to be wrestling with that and how we manage those, how we measure those placements later on. But anyway, listen, bail out now. It won't hurt my feelings. Now let's talk about what is legal analytics. It's one of these terms that, like innovation, is gradually expanding to sort of consume the entire world. And so there's sort of a question about what we mean by it. What we mean is software-enabled analysis and visualization of different kinds of legal data to accomplish descriptive and predictive goals. I always have to go to my notes to remember this. But the bottom line is this idea of treating text as data and leveraging the extraordinary developments in the last few years, both in terms of prepackaged algorithmic tools and also, of course, just computing firepower that we have available to us, which enables us to look at text in ways that simply were not possible before. And that has led to some extraordinary chains of adjectives. Revolutionary, disruptive, innovative, dizzying implications, all of that. So we're very proud of that. Anyway, an example of this is moving beyond traditional legal research to treat problems as data science problems. In other words, you're allowing the data to tell you what patterns are there, rather than manually filtering through the data and imposing sort of your own structure on the data and as a way of analyzing it. One way that we talk about this is that we allow the documents to speak for themselves. By the way, at any point, raise your hand, I should come chase you down and look at your name tag and interrogate you, but I'm not going to do that. But yeah, raise your hand. I'm also going to use a lot of just plain old PowerPoint slides. Sorry. Anyway, so the thing that we are also, of course, interested in is training students in predicting. This, of course, is the Holy Grail, predicting outcomes. This is what firms are interested in. This is that famous slogan from the Lex Machina folks, right? Win business, win cases. It's pretty pithy. I mean, that's really good stuff. But that's sort of the Holy Grail. If you want to look us up, we're at law.gsu.edu/LAII. And you'll see our very slow website that is in the midst of being redesigned and will be hosted on new stuff. We want to quickly go through what we're offering. So as far as courses, one of the things that we've tried to do, and tried very hard to do, is both make these courses inviting to people who might only want to take one course and then move along, as well as making this rigorous. We're trying to make this something that is more than just legal analytics for dummies, right? Something more than that. So what we've got, and I should tell you where we are. How far have we gone? Where did we start? All of that. Our certificate will formally begin this fall. Our LLM is approved for this fall. Our joint degrees begin this fall. We taught Legal Analytics 1. We called it just Legal Analytics. But we taught Legal Analytics 1 last fall. We taught our experiential course, which is the Legal Analytics Lab, in spring. Those are 2 3-hour courses. And that's what we're building on for the fall. One of the critical things, by the way, in developing this, and I think just critical for anyone interested in developing programs like this, is leadership buy-in. Georgia State has a fairly unique history around analytics. Analytics mostly in terms of student retention and student success. But the word analytics has a certain cachet at Georgia State. We have done amazing things in terms of graduating historically challenged groups of folks at the same rates as traditional majority students within Georgia State writ large. Also, I should mention, Georgia State is the largest university in the state of Georgia, 51,000 students. We're in the heart of Atlanta, if you haven't been there. It's not out in the country. But anyway, what was critical was this leadership buy-in and interest in the program, because analytics has been a success for the university itself in a different way. They were interested in exploring how could we build on that within our program. What we've got are Legal Analytics 1, Legal Analytics 2, and a Legal Analytics Lab, 9 hours. Core courses that students can take. Legal Analytics 1 and 2 have no prerequisites. You don't have to come in with a STEM background. By the time you take the Legal Analytics Lab, you need to have had Legal Analytics 2, or you need to take that at the same time. If you're going to get the certificate, and I do think this is a little different for us, you need to have had Calculus 1, Calculus 2, and a programming course. And so our compromise to bring people in who might not have had that as undergraduates is 6 hours of intensive coursework, and it's intensive, and it's like 5 in the evening to 9:30 in the evening, Monday through Thursday, all of June and July, and these poor students are in there right now. So shout out to any of them. I know some of you, and they will never see this, but they're doing great. But our goal was to bring in students who recognize that this is going to be important to them in their careers and see that this is an important area of the law, but didn't have that. Let's imagine that they were a poor Spanish student or poli-sci student, and they hadn't had this background. They've got that ability, although it's a stretch, it's tough. And so we've got 6 students right now, I think, who are doing that. I'll have 12 certificate students starting in the fall, by the way. Dual degree students do a 21-hour lockstep curriculum to get a Master's of Science in Analytics at the university within the business school. So the student that we have who's doing that right now has done 1 year of law school. They were a mathematics student at Spelman. Did not want to lose their math. This is the kind of thing that just warms my heart. She was worried that she was losing her math. She is now taking a year away from law school to go do the Master of Science in Analytics. So she's going to do the 21 hours of analytics this year. Then we get her back at the law school. That's how we're doing that. The LLM curriculum is for our domestic LLM students. We can't figure a way to get our foreign students enough of everything they need. So currently that's going to be for domestic LLM students. And that's kind of necessarily with the LLMs a custom curriculum. They're trying to fit in so much in 2 semesters or 3 semesters that we are working with them to customize something. Anyway, the courses. Legal Analytics 1 is an introduction to research design, quantitative methods, design-based thinking. That course is taught by a PhD JD that we just hired. She was a PhD poli-sci econometrics person who then went to NYU Law School, then went to an antitrust firm in DC. We've got her back, and we're very, very excited to have her starting in the fall. So we have 3 faculty members focused in this area. One of them is her primary appointments at School of Business, or at the College of Business at Robinson. But the other 2 are within the law school. The second course they take is Legal Analytics 2, which is data science methodologies applied to law. There's an experiential component with that. One of the key things in that course is that we have teams of MSA students. These are primarily, not primarily, these are business students, right? So we have teams of MSAs and law students working together. And this is fascinating to watch. I got to sit in on the lab this semester, and I did a little bit of work with them. But I got to sit in on the lab this semester, and to just literally watching people who approach the world in fundamentally different ways. You know, and the first time the MSAs are like, that's a Pacer docket sheet? Well, they should clean that up. Yes, they should. But it really is an interesting cross-pollination there. And pollination. One of the things that we're working on is we're, again, through the summer courses and the focus on a deeper math and programming background among the law students, we're hoping to even enhance that discussion. Because you do have situations where the law students are all over here and the MSAs over there, and it takes work to bring people back to the same page. Yes, sir.
So do you allow purely MSA students to take these classes to get a leg up into the legal world, even if they never take any other law classes?
Yes, we do. And one of the things that, and I'll hit it in so the question was, do we allow MSA students to take these law classes? They are 2 of them are cross-listed. The MSAs will get credit. There is a legal, and it's very confusing, and if we were marketers, we would have sorted all this out. One would be blue, and one would be yellow. But we have the Legal Analytics Lab that is part of the business school. We have the Legal Analytics Initiative that is part of the law school. So the students, you can be an MSA student with a focus on the Legal Analytics Lab. So the idea might be that you would go into a legal services position in working alongside.
That's different than a dual degree.
Exactly, working alongside lawyers. Great question. Let me mention one other thing, and I don't want to take too much time on this. I've got a bunch more slides, and we'll get into some of our research projects in a minute. On the MSA coursework and electives, if you're going to get a certificate, you have to take 6 hours in the business school. Okay, that 6 hours may come from those prerequisite courses, the intensive math and computer science. Or for students who are coming to us, and honestly, we're getting a lot of students from Georgia Tech who are coming into law school, and I think are just going to be well, it's really interesting. I think they've got lots of possibilities when they get out. But then you'll take 6 hours in the business school, in the analytics program, and that tends to be a much deeper dive into text analytics, into these various systems. So we have a challenge, and I think any of you who've worked with cross-disciplinary program design within law schools have probably run into this. There's a limited number of hours outside the law school that students can count towards their law degree. So when I'm sitting down and advising my non-STEM students, I tell them, you're paying there's a little bit of a penalty here. You know, you're going to take the 6 hours of foundational courses. We really want you to take the additional few hours of courses in the business school to get that extra exposure, but you're not going to be able to count those towards the 90 hours for the degree. And I honestly believe that's why some law schools take the coding, etc. classes in-house. And that may be something that we explore on down the road. I'm going to leave this one, problem solving, demand, opportunity. We feel that there are significant reasons and rationales for exploring analytics as a discipline within law schools. One of the things that I do want to mention to you, this idea of computational thinking plus data, plus quantitative methods, plus computer science seems incredibly valuable and very complementary to the kinds of thinking that we also engage in traditionally within law schools. The idea of breaking problems down into small pieces, the idea of looking for those patterns, of generalizing, of looking for a solution to a multitude of problems rather than each solution individually. Historically, the ways we've attacked that may have been less efficient than the ways that someone in computer science might go at that. But we feel like there's significant overlap there, and we really want to focus students on that mode of thinking. Again, it's fascinating to watch the dialogue between the JD students and the MSA students. A little bit of background here. The only thing that makes this work for us is a deep partnership with Robinson, with our business school. Not every university has the advantage of having that kind of linkage, but we have a very close partnership. We have two deans who are really interested in working together. There are a number of issues that raises. You know, the business school has 1.5 credit courses, for example. I mean, even, little things like that. Major things like, if a law firm is paying you money, how do you split the revenue? And that gets complicated, right? So we've been very fortunate to have that. The business school has something called the Institute for Insight, which has 4 separate labs: the Social Media Intelligence Lab, FinTech, an operations/supply chain group, and then this overall Insight Lab. That's their mission: world-class research program, use of text mining, machine learning, artificial intelligence. We've adopted that approach at law school. I promised you sloths and croissants. This is your second opportunity to bail out. You can leave now. You'll know exactly what we're up to. So the challenge here is that it's hard to really put up something that is compelling, that involves text recognition and is very short. Image recognition, pattern recognition with images is one of those things that comes up over and over and over again. And of course, computer vision has been one of the first significant applications of supervised learning. You can Google computer vision fails for fun if you want. Those are amusing. But this, of course, is a set of tasty pastries and very slow marsupials. They don't all alternate. You know, it's like, how would you sort out as a human, how would you sort those out? Humans are actually really, really good at this sort of thing. Computers not so much. So we have a lot of different ways that we do this. So imagine, what would be a way to tackle the sloth versus croissant problem? How might you begin? What are some distinguishing features?
Hair.
Hair. Does it have hair? Probably not a croissant.
Hopefully.
Are there green things in the picture?
Are there what?
Green things.
Green things in the picture. That might work.
Is it wrapped in cellophane?
Is it wrapped in cellophane? The students always love pointing out the packaging that we. Yes.
Eyes.
Eyes. Does it have eyes, or are those dots of chocolate? You know. So you can imagine, right? This is the whole challenge. This is the first generation of artificial intelligence. Was the idea of building rules-based systems. You have how many rules, right? The problem is you have to create more and more and more and more and more rules in order to accommodate for the occasional sloth that shows up wrapped in cellophane, or the occasional croissant that has eyes, right? It's always the edge cases, right, that get you. So of course, the way that we do this in the kinds of approaches we're talking about in the legal analytics tools that we're generally using is we use supervised learning. Supervised learning allows us to use more acronyms. No, it allows us to. I get to talk about my next one, right? This is why the robots are not taking over, contrary to Mr. Roboto back there. The robots are not taking over. Yeah, they're not taking over yet. Because you still need SMEs. Right?
Mm-hmm.
Anybody?
Subject matter experts.
John, okay. Thank you.
Sorry.
I saw her lips move.
I'm not
when you were
sorry.
talking. Subject matter experts. And so when you're looking at legal concepts, right, the idea is you take, let's say you've got 5,111 employment law cases in the Northern District of Georgia, and you might take 1,000 of those and give them to a subject matter expert, otherwise known as a SME. Okay, well that's very good. How about lawyer? You give them to a lawyer to classify that first 1,000, right? What are the factors that led to a grant or denial of summary judgment in favor of the defendant in a wrongful termination case? Well, I'm just making that one up. We didn't go that direction. But once you got that 1,000 and you've trained on that 1,000, you train your model on that 1,000, you present it with the other 4,111 and let it go to town. If it were evaluating sloths versus croissants, the answer that you get back, it would not probably be able to tell you how it made that decision. It would be some complicated combination of green plus packaging plus eyes plus fur plus whatever. But that's what we're doing. That is the move from rules-based AI to data-based AI. We go from 1,000 rules to 100,000 cases, with 10,000 of those cases, 20,000 of those cases looked at by humans, and the rest classified. That is a kind of machine learning called supervised learning, right? And so that's one of the things that we really focused on. All right. So anyway, I'm just using this. Obviously, that's a trivial, silly example, but this is sort of an idea of the kinds of stuff we're doing. So let's talk about some of the projects that we've done at Georgia State. These are, I need to check something real quick, so I want to make sure we've got some time. I may whiz through some of these. These are what we call sprints. Damn. When you think of a sprint, what would you how long would you think the duration of a sprint might be?
Well, an athletic event, a couple of seconds to a couple of minutes. Technically wise, about a week, tippy tops.
A week, 2 weeks? Now, if you told academics that we're going to do a sprint, how long do you think the project might be?
18 years.
I just line them up, and you just hit them out of the park.
And it would be 85% done.
It was very strange to me. When I was interviewing for this job, I kept being told that we did sprints. And I'm like, oh, cool, code review. I like it, agile. We're going to sprint. There's going to be a scrum master. A sprint is a semester-long research project, which is a sprint in terms of academic research.
And geology.
That's lovely. And geology. So anyway, here was one of the projects. One of the things that's really interesting is trying to help directors and officers, liability insurers, try to figure out when they are more likely to have to make good on the policies that they're issuing. In other words, when the directors or officers involved and insured are likely to be sued for things that they've done or not done. And so what we were doing is looking at text analytics and machine learning to review the Stanford Securities Litigation Database to look at fact patterns that could be used in the underwriting process. And the question was whether we could get case features and facts of claims that resulted in litigation, so that we could look at a predictive model that would help these D&O underwriters. That was done for a company in Atlanta, Star Company. And this involves extracting text from complaints using good old-fashioned Python, just to pull text out of complaints, to look at sectors, industries, fact patterns, types of alleged misleading or false statements. That's one example of a research project. Another one, this employment litigation sprint, we've been working with this set of data for a significant time now. A local plaintiff's employment law firm came to us and was interested in analyzing that 5,111, that number's not made up, those 5,111 cases, employment law cases in the Northern District of Georgia. And they're trying to figure out the sort of the pathways through litigation. And trying to figure out how long it takes a case to make it through based on particular factors. That's of course incredibly important when you're trying to figure out whether to take a case. Both the likelihood of success and the amount of time and investment required. Are you going to be able to settle before discovery? Are you going to have to go through intensive, expensive discovery processes before you finally get to the settlement table? And that was another one. And this one involved taking apart PACER docket sheets. And there's loads and loads of interesting work in doing this. There are a number of projects around the country, we're not the only one by far, including some commercial projects, that are all about disassembling PACER and putting it back together again. But the amount of really useful data in docket sheets is astonishing. The amount of really mundane coding required to tear all of this apart and put it back together is also amazing. So one of the things you keep hearing over and over again, and one of the things that's useful for us to share with our law students who are in these programs, is that you spend 80% of your time cleaning up the data. 80% of the time is taking whatever messy human stuff you get and turning it into some format that you can spend 20% of the time trying different models on. So anyway, we were doing this kind of stuff here. And we came up with this long before we saw Docket Watch and Fast Case. I think it's Fast, it's in Walter.
Docket alarm.
Oh, Docket Alarm.
Last case just purchased docket alarm.
Yeah. Before we saw Docket Alarm, and it was just great because we had Walter's at a talk and he's giving this talk and he pops this up. I mean, their version is very, very similar looking. And we were like, huh. And I was like, well, that's a bummer, but I work with such fantastic, optimistic people. They're like, look what we did. We did something that was just like that here at the law school. And I was like, that's cool. Anyway, this idea of figuring out both the percentages of where cases settle, how far they get, how long, this is of incredible economic importance to everyone involved. And this is really interesting stuff.
Ed should have purchased you.
Not me, I just run the program. Shout out again to Ann and Charlotte, who actually do all the math. I'm learning as fast as I can.
Ed should be hiring your students, is what Ed should be.
Well, we're talking.
I was gonna,
Actually,
that's how much.
yeah, we were talking. Anyway, so one of the things that you wind up doing is a lot of this kind of thing where you're parsing, you parse out additional data. And so one of the things I want to mention for those of us or those of you who have done more traditional coding where you're just reading through chunks of text and using regexes and whatever to extract things, you've still got tons and tons of that to get to the features that your machine language model eventually will use to come up with its own magic stuff. So there's still a lot of that. We're going to skip right through that. All right, mutual funds. We were looking at text analytics, machine learning, just blah, blah, blah. I'm not supposed to read slides. You can read. I've learned so much. But the thing that was interesting about this, and still catches me a little bit by surprise, is just the volumes and how quickly, given modern machinery, we have a high-performance computing cluster at the business school that we use. But this idea that you're dealing with 206 million words, 497,000 filings that we're slurping through, looking for patterns. And this whole idea of language in things like these declarations. The following are the principal risks of investing in this fund. There is no guarantee that the fund will make money. We're trying to do sentiment analysis on language that is pretty blurry and can either be stated in the negative or in the positive, And it's really interesting stuff. None of this is easy, but it has turned into a really exciting area for us to explore and something that our students are really engaging with and enjoying doing. So this is a couple of other points we wanted to make about the data we've been messing with. Is that most of the data is missing. I mean, this is the big thing, right? A tiny fraction of cases ever wind up with an opinion. I mean, all you ever get is the docket sheets, and the complaint, let's say, and all of those documents. But most things settle, almost all of them settle. And so this idea of trying to make trying to make meaningful statements about large bodies of areas of dispute when many of the cases are just not available to you. Much of the data is not available to you. It's an interesting challenge. Our data is so messy. Again, I'm just drive home this idea that in those 5,111 cases that we were looking at, 1,000 of them were pro se, handwritten employment discrimination complaints. And we didn't have staff to deal with that. And so that's a really interesting population. Because what population of people is that? Those may be the people who are least well served by our justice system and perhaps most in need of help, reform, change, something. And they're just not amenable, given our resources, to this kind of analysis. So it's another interesting side note. And the other thing that, again, I'll just drive this home again. We were fortunate to have support on the curriculum committee for making 2 of these courses experiential. The ADA, of course, requires 6 hours of 6 credits of experiential learning now. You can knock out your experiential learning requirement in our program. This also opens the door to really exposing them to the amount of grunt work involved. And this idea that this is work. And so you balance the idea, there's no pushing a button. There's never pushing a button. But when you talk to vendors, it's always pushing a button. You just push a button, you get an answer. Law is nuanced. This is another challenge. As lawyers, we tend to want to really focus in on the nuances. Sometimes our clients, our customers, the people we work with just want to know whether they need to move out of the way. This is another challenge for us and requires more work for us as we are trying to take some of these nuances, these it depends, and we find this over and over again. How many of you have run into the concept of overfitting? Okay, so those of you who've done stuff with models, predictive models, will know that it's sometimes easy to create a predictive model that just clobbers your test data, nails it every time, and is not very helpful on the other data, the full set of data. And that's because the model is overfit. It's drawing inferences from very specific language in a very specific set of opinions involving a very specific set of facts. So the challenge is to create a very simple model that is capable of dealing with the number of variations that humans have or create and that has some predictive power. And we continue to struggle with that and wrestle with that. We've got this, just a reminder that mostly what we're dealing with is loads and loads of unstructured text, more every day. We've been working with, as I mentioned, Alston & Birch, the large international firm. A good example project that they're intrigued by is time and billing. And trying, because clients are now demanding that you budget for every project. And you're held to hitting certain targets. One way to predict the cost of a matter is to go back through your historic time and billing records, throw that into a machine learning model, and try to predict future time and billing. The challenge, of course, how many of you ever filled out a timesheet at a law firm? It's hard to do it right. And it's hard to do it the same way every single time. It has become somewhat easier because of the ADA's coding now. Okay, I'm almost done. Pretty close. The path isn't clear, but the results that we've had so far have been promising. Our students seem very energized by this. Where we are currently, we've got 3 full-time faculty. We've got myself doing whatever I do. And then we've got these 3 courses on the books, the certificate, the dual degree, and the LLM. We've got 12 students in the certificate program this fall, 1 student doing a dual degree, 2 students who look like they're going to be doing the LLM. So we feel like we're moving in the right direction. And that's it. Well, you have this goofy picture of me and a great picture of Professor Ann Tucker, who actually did a lot of the work underlying all of this, and is a treat to work with. Do you all have questions? Gary?
Ben, I don't know if you saw from a couple days ago that France banned judge analytics.
So, okay, so Gary's question, did we see that France banned judge analytics? Yeah. And I was like going to try to do something clever like a les analyses or whatever, right? But I decided not to, except for now. So we've started talking about reaching out to some colleagues to do a quick student overview or a small get-together around this. So what's happening, and you all may have been approached by, I always forget their name, there are multiple companies out there that are doing judge or judicial analytics now.
Gavalytics.
Which is?
Gavalytics.
Gavalytics. I always think of them as they're in the West somewhere.
Yeah, we're in California.
And then there's a Florida company, I can't think of their name. But there are multiple companies that are now aggregating all of the background that they can find on particular judges to give you a better sense of how particular matters are going to play out in front of them. So in France, they just recently passed a law banning this, banning the use of analytics to analyze judges' performance.
Which is open case law.
Which is,
Open case law.
and that's the fascinating thing about this. To a certain extent, right, this is how our business moves. We go slamming the needle way far over here. Let's make all the case law open. Let's make it free. You know, vive le case law open. Anyway, the something libre. Anyway, so we did that, and then this was the reaction, which was, oh my, now they've got all that data. They're going to, and companies had already announced that they were in fact going to analyze the way particular judges had responded. There's an interesting thing, at least in the article that I saw, which was in Artificial Lawyer. Interesting comment there. Does anyone know why this would be particularly troubling to those judges as opposed to perhaps in the US? So different legislative regime, right? A different judicial regime. In a civil law country, you're supposed to just be following the statute as written. Judges do not make law. There's no common law, right? And so intellectually, they're saying there's no value to this. Everything depends on the law and the facts of a particular case. It's not establishing precedent. But then there also was a suggestion in the article that there was concern that they would discover that some judges were deviating from the code. Ooh la la. Which of course, I mean, of course they are, they're humans, right? Anyway, great question. Again, in Artificial Lawyer, they suggested that that was the first time that any law like that had been passed anywhere. I will bet it's not going to be the last.
That was my follow-up question.
You know, I think this will be a knee-jerk reaction. No, you can't analyze our decisions. That's not fair. John?
Isn't this analogous to, I can't remember who, it was it Congress saying that the CDC can't analyze gun deaths as a health problem? You know, it's like it's saying the same thing. We don't want to know, or we don't want to know that way because it's too
That's
hot
an
button.
interesting, so that question for those at home is, well, except you may be caught by that one, whether this is analogous to our limitations on analyzing CDC gun deaths. I don't think that's actually stopped anyone. I will add one kicker, is that analyzing the French judges' opinions in this fashion potentially subjects you to 5 years in prison.
That's the law. That's the law.
And I was like, whoa, okay.
Well, I'm sorry, I was going to say another difference would be that in John's example, that's the executive branch of the government telling a government agency what it can and can't do, whereas we're talking about public legal information, and we're saying that private actors can't use this public information in a particular way.
That's a fantastic distinction to make. This feels very overreaching. I mean, that whole idea that public legal information can only be used in a certain way. Yeah, that feels
Or
very...
like the state code of Georgia.
Oh,
But-
what-
Which, Chris, what's
I
the
did-
deal
I did
with,
go
what's the
there.
deal with the
No,
state code of
don't
Georgia?
say my name on there.
I want everyone to understand that Georgia State continues its copyright litigation. Georgia State's still out there fighting for you.
I'll say
So
that.
I'm going to play devil's advocate, not that I disagree with anything that's been said, but
You want my
could-
students back?
Yeah, you could argue that this kind of limitation is actually evens the playing field so that people don't get an advantage just because they can afford to do data analytics.
So this idea of people getting an advantage because they can afford to do data analytics is really interesting. I mean, that is hugely interesting. I'm about halfway through Automating Inequality, which is all about using systems to theoretically at least perpetuate systems of inequality.
Hatfield, right?
Blanking on the last name.
Is it Julian Hatfield? No?
No,
No,
I thought that was Weapons of Mass Destruction, maybe, but
Alright.
That's Kathy O'Neill.
Kathy O'Neill, and someone will Google Automating Inequality.
Virginia Eubanks.
Virginia Eubanks, there you go, that's it. But that idea that we are moving into a world where people with access to computing clusters and data and algorithmic knowledge and Georgia State Law MSA students will have an advantage over people who do not have that. And I don't think that's ever stopped us before in anything else we've ever done, but it is certainly something to be aware of. The argument, of course, is that if the data is open, if they make the data open, and 99% of what we do is done in Python, and we use scikit-learn and some variants on that toolkit, which gives you access to about 15 state-of-the-art machine learning algorithms. Most of those tools are all open and available. There's a gigantic gap between saying the tools are there and you know how to use them.
None of the librarians in the room who dealt with the 1,000 and some pro se patrons that handwrote the complaints believe that that's the answer to their access to data analytics.
I think you're pointing out something that is really important. Again, though, I don't.
Right, I'm not saying, and that's certainly not, I'm not saying that's why the French passed that law. I'm confident it's not. But I think it's a conversation that we need to have about the technology and the analytics.
In general.
Yeah.
Yeah, I think absolutely.
To build on that, I'm really trying to remember the name of the company and I'm blanking on it, but at the ABA Tech Show a couple of years ago, there was a sponsor there that does predictive analytics on pending legislation in state houses and provides information so that people can look at which versions of language are more likely to make it through, which was really alarming to me when you think about organizations like ERIC that are trying to get, who's going to have access to pay to a company like that to tell them how to get a legislation through? The same people who have access to lobbyists and have reasons to try to get laws passed that would benefit a company, not the citizens at large. And I think that that's the other side of this. It's not just who can determine the outcome of a case, but who can determine what the laws of our country are and how to get things in that benefit them. That's really, it creeps me out.
And I think that's incredibly reasonable when we're all being constantly subjected to A/B testing by increasingly sophisticated marketers all the time. Why would you not test market legislation?
They have been for decades.
Yeah, and then this idea that test marketing legislation to make the least objectionable version of the thing that accomplishes your goals, make that into law. That is something that is challenged. You could make an argument, one of the things that we talk about when we talk about this program is that we're trying to create, and I know this is a cop-out, but we're trying to create more and more educated consumers. We're trying to make that conversation between the service vendors and the consumers, and of course we're talking about sophisticated lawyers, but as opposed to people who really need help perhaps, but trying to make them better consumers of the data. What models are you using? How did you train it? What assumptions are baked in? One of the challenges with all of this with machine learning, of course, is that it's always backward looking, right? It's always, you could argue that about the law, but it's always looking at what came before to build its predictive models for what's coming ahead, what's coming next. And that's an interesting challenge with that as well, sir.
What's your general framework for structuring partnerships with people who are paying you for them? Like, how much are you, and this kind of gets to some of these comments, is how much are you giving away? What's the expectation? Is it, especially where there may be some private advantage, sort of what's your understanding or aspiration in that area?
So our goal, and what happens, and I do wish Ann were here, because she knows the details of this better than I do. But when they come to us for a sprint, any of the data that they give us, we get to use for our research. Any of the conclusions that we come to, we publish.
Okay.
There is a challenge. There's always a challenge, and this is a very entrepreneurial university. Chris can also speak to this much more than I can. Where I was before, we did not do these kind of partnerships with private entities. Georgia State is a big believer in reaching out to potential partners. And so our training at Alston and Bird is 3 training sessions done at their place, and that's sort of contract exec ed. With an MOU with the business school and an arrangement to split the revenues.
My apologies for being late. If you covered this,
I'm sure I
look
did.
up the later. So I taught advanced legal research for the first time, and I expanded the section on legal analytics, which used to be 15 minutes, into an entire class section.
Great.
And I had the students use context and use lex machina. And I found that the problem was, for me, is giving the context of how attorneys use this. When I was in law firms, it was largely the partners would ask the associates to ask the librarians for this information. And I would provide them this information, but it wasn't the associates themselves using it. They would pass it on to the partners who had all the legal strategy and knowledge to actually put the information into the uses that they thought were most appropriate, whether that was approaching a new client or trying to figure out if a new judge would be friendly to their motion, etc. And try and provide that to students who haven't practiced, who haven't developed that sense of what legal information provides the best strategy for them.
Right.
How do you inculcate that into turning the data into actual useful information?
Thank you for not saying actionable information. Actual, useful information. That is such a great question. One of the things that when we talk about navigating that boundary between these private partnerships and then just hypothetical research assignments, we hope that we can provide some of the framing, because it's coming to us from, for example, this plaintiff's employment law firm who said, here's our challenge. We have many, many people coming to us. We have difficulty evaluating which cases are the ones that we should really throw resources into and which are less likely to be successful. That's a very practical problem. And we're able then to provide that context to the students. So we get a little of that, but you've identified absolutely this real challenge, and this goes back to what is the mission of law schools in the 21st century, right? We're supposed to turn out people who are practice ready. But there are an infinite number of practices, right? And if they have never worked before, they need 2 or 3 years in a law firm to even begin to have that larger context in many law firms. And I'm obviously painting with a very broad brush. But they may need a few years before they even see the context of a whole case and a client relationship and what might be strategically important. So those are real challenges, and we're going to be struggling with that as well. One of our other issues is, there's that whole thing about whether you're talking about the law of technology or the technology of the law, this whole dichotomy. We are not talking about law here 99% of the time, except for taking things apart to build rules. We are talking about learning some fairly complicated stuff that will help you theoretically be a better lawyer or be a better participant in a law firm, just to be clear what we're after. I think I am at 11:59. I'm going to wrap up. Thank you all very much for your attention.